In this chapter, we're going to look at discovery and admissibility of medical records and differentiate between those two terms. As far as definition, discoverability is access to documents or witnesses by parties to a legal proceeding. And a document is discoverable. If it is, then it must be produced to the party who requests it. So to discover something, to find it, that's basically what discoverability or discovery is. Discovery is the act of accessing documents or witnesses. Admissibility refers to whether or not documents, objects, or testimony may be admitted formally into evidence. And so to differentiate between the two, discovery means access or finding information or any type of thing that is in that pre-trial period where they're preparing for a legal proceeding. But admissibility is all these things that are found, can they actually be used in the legal proceeding? There are rules in every state regarding the admissibility of evidence, also discoverability of evidence. Now, in regard to admissibility, the judge, jury, the arbitrator, or other decision maker may only consider evidence that has been admitted. Excuse me. And most of you have seen court shows on TV, and you'll see them admitting evidence. It could be a document, it could be another tangible item, it could be a number of things. But discovery is finding it, admissibility is using that evidence in court. Now, discovery, as I said a minute ago, is the process. So pretrial access to either witnesses or documents, allowing parties to a lawsuit to discover facts and possible evidence in the case. So discovery is before there is a trial. It's getting ready for the trial. And there are different methods of discovery. There's an oral deposition. Now, a deposition is taken under oath. An individual is recorded. There is a court reporter there. They're sworn in. Attorney does the deposition. And so that's one way of gathering evidence or information, is in an oral deposition. Obtaining court permission to examine documents, and by this we mean a subpoena or a court order. Sending written requests for information. Even though this is a court case, it doesn't mean that everything has to be subpoenaed, that there always have to be subpoenas and depositions involved. If there is a request and there's permission from the patient, and the patient signed a release for or signed a consent for release of information, an authorization, then it's okay. But that is part of discovery. And also there are interrogatories. Interrogatories, that's a written list of questions that must be answered. So one attorney would send a list of questions called interrogatories to the other attorney, and the other attorney's client is responsible for answering those. Again, they are signing a statement swearing that they are telling the truth on this. So these interrogatories are another method of discovery, or just discovering things before the trial. Your book talks about physician-patient privilege. Now, this privilege may protect records that have been discovered from then being admitted as evidence. And that's very important to keep in mind. Just because something's discovered does not mean necessarily that it's admissible. It may be, but just because an attorney has particular evidence that has been discovered, that evidence then has to meet those rules of admissibility to even be used in court as evidence. And so they don't go totally hand in hand. But when we're talking about physician-patient privilege, this privilege may protect records that have been discovered from being admitted in court, and there are laws regarding physician-patient privilege, and they will vary from state to state. Now, the privilege belongs to the patient, not the physician. So the physician could not refuse to testify and cite physician-patient privilege. It's the patient's privilege or right. And so maybe the physician doesn't testify, but it would only be on the request of the patient, because that is the patient's right, not the physician's right. But most courts will hold that if an individual files a suit that places his or her own physical or mental health in issue, then there is implied waiving of that privilege. A waiver, to waive something, means to make it, to give up a right, in this case, the privilege. And so what that's referring to, here's an example that may make it a little more understandable. The book gives you a scenario about a patient who was seeking compensation for physical injuries and pain and suffering, and they had to allow the opposing parties to view medical records that are pertinent to those injuries. So if a patient or a person brings up the issue and saying, I've suffered, or I'm suing for pain and suffering, or the injuries that were caused, then they are basically waiving the privilege of keeping their information confidential in regard to the lawsuit, because they brought the injuries up. And they can't say, well, I had pain and suffering, I had injuries, but you can't look at my medical records to determine if that's really the case. And when I say you, I mean the opposing party. Now look a little more at admissibility. Most courts hold that medical records are as admissible as evidence in court. So medical records are subpoenaed. They're taken to the court. They're certified. We turn them over, and they can be used as evidence in court most of the time. But there is this little rule, it's called the hearsay rule. And this may get a little confusing. I'll tie it all up after we talk about all these definitions. There's something called hearsay. Many of you have heard that term. I object, Your Honor. That's hearsay. What's hearsay? It's a statement made out of court that's introduced into a court proceeding for the purpose of proving the truth of the facts asserted in that statement. Normally, hearsay is not admissible. And if you think about a medical record is full of statements made out of court. They're not, the medical record itself is not made during the court proceeding. So medical record could be determined to be hearsay, therefore it wouldn't be admissible. But in the first sentence I said, well, most courts hold that medical records are admissible as evidence in court. So generally, hearsay is not admissible. But there's something that's very, very important when it comes to medical records. There is a business record exception to the bar on hearsay. So if a medical record is hearsay, but it is admissible, it's because it's a business record. Medical records are considered business records, and there are laws on the book as far as admissibility, and there is something called the business record exception to hearsay, to the bar on hearsay. Business records, by definition, are kept in the normal course of business at or within a reasonable time after the event or events were recorded, and are assumed to accurately reflect the course of events. And so a medical record falls into this business record category. We normally don't think of medical records as business records, but they are. They're defined as such because they are kept in the normal course of business, meaning medical records kept the same on every patient that's seen at a facility. And the medical record, the entries are made on or around the time that events occurred. And so it's assumed to accurately depict that patient's, whether it's their hospitalization or their physician's office visit or something like that. So that's why medical records are considered business records. Now within the facility, there's other business records. There are billing records, abstracts of records. There are different types, but the medical record is just one type of business record that's kept at a medical facility. And just go on to say this now, is that many times when you get a subpoena for a medical record, it will also say, and all billing records, and many times it will say, and x-ray reports. And so a subpoena may cover more than just the medical record, but it is a business record. And when you go to court, the first thing on that certification, if you mail copies of a record to answer a subpoena, or if you actually have to go to court and deliver the records and be sworn in, what they're going to ask is this the medical record on Jane Doe? Yes. Was it kept in the normal course of business at your facility? Yes. And so when you have to do that, you're meeting, or you're helping the attorney meet those rules of admissibility. That's what it would make it admissible. Now, when the certification, if we don't have to show up in court, but we certify the records, and you have an example of a certification in part of another record that would vary from state to state, but in Alabama, you have to do it verbatim and fill out this form, and it says these records were kept in the normal course of business, and that this is a true and accurate copy of the medical records on patient Jane Doe. And so that we always have to get that in, that these are business records kept in the normal course of business. Now let's look at other healthcare documentation. It may be sought by a patient or that patient's attorney if the patient is suing the facility or a particular healthcare provider. Other things that may be sought: credentialing reports. And when we're talking about credentialing, you hear more about that in your quality improvement class, but credentialing is all the information on each physician on staff or other healthcare providers, their license, their history of any type of practice other places or anything, let's say lawsuits. It's copies of their educational information, their credentials in order to be able to practice. So those are credentialing reports, and so sometimes attorneys will ask for these. Joint Commission survey results, incident reports. Now we've talked about incident reports before, and I want to talk a little bit more about them in just a second. Surgical review. When I'm talking about that, there are different committees that review different things within the hospital, different committees of the medical staff. And so sometimes there will be a surgery review committee, and so there will be minutes from those committee meetings, and those will be kept. They may be asked for. Infection control committee minutes, patient complaints, peer review records, risk management reports, quality improvement records, and others. And all of these are not part of the medical record. And some of these, actually there are laws that state these cannot be discovered. These types of records cannot be discovered, but we have to maintain them properly for them not to be discoverable. So even if an attorney sends a subpoena for these types of records, there are laws on the book, especially in Alabama. And again, I know I keep saying I'll show you that later, but when we go over the Alabama Law Manual and Alabama law specifically, I'll show you in regard to quality improvement records or quality assurance records and incident reports are included in that, that they are not discoverable, meaning we don't have to give those up. So some of these types of records are protected by law against discovery. An example, quality improvement and peer review programs rely on committees that collect data, they generate reports on the performance of individual physicians or the treatment of patients. These programs, the reason that they're there and these committees are doing these reviews is for improvement, to find out, have we done something wrong? How are we doing? Are there ways to improve the way we do things? So if these records can be discovered, then the participants in these committees would not be as forthcoming or candid or even conduct these activities if they knew that everything that was said, if these committee members said that, okay, well, this may end up in court. And so these particular types of records, quality, I know in Alabama it's quality assurance, peer review, incident reports, are protected and they cannot be discovered. Because again, this is for improvement. And so people would just not want to do a whole lot of quality improvement activities if they knew that everything they were trying to improve could be turned around and then just used against the facility or particular providers. Now, even if the records are not protected by state law from discovery, they may not be admissible because they're hearsay. The medical record's a business record, so we talked about that. It meets the bar on hearsay, so the exceptions, that business office record rule. But these other records aren't business records. So these records usually contain opinions and not actual factual occurrences, opinions by peers or different committee members. And so notice in that top sentence, even if the records are not protected from discovery, even if they're discovered, they may not be admissible as evidence because they actually are hearsay. They don't meet that business record exception to the hearsay rule. Now, when you have distribution of minutes from any type of committee, especially one of these quality improvement or peer review committees, they should be very limited. You don't just take minutes, or whoever's taking the minutes, and then just make photocopies or emails of them and send them off. Usually in these circumstances, the minutes are made, they're reviewed at the next committee meeting, and they are filed in the administration offices, or it could be in the quality improvement department. But everybody on the committee is not given out a paper copy of the minutes or an electronic copy of the minutes. And there are very good reasons for that, because there have been cases where maybe a disgruntled employee or something like that has gotten a hold of copies of minutes. And I heard of one instance where the ex-employee actually sent it to the papers, these committee minutes, and had them published in the paper. And so it's very important that the distribution of these minutes be very, very limited. Now let's talk specifically about incident reports. That was on the list, the incident report. And if you remember, an incident report is filled out on any type of incident. It could be a patient. Maybe a patient fell out of bed. Maybe, say, a visitor fell in the hospital. Maybe the wrong type of medication was given the patient, or anything like that. Anything that's out of the ordinary, an incident report should be developed and completed. And these are listed in many states as protected from discovery, but they have to be maintained in a certain manner. Never, ever, ever, ever put an incident report on the medical record. So if there's an incident report on a patient, say for example the patient did fall from the bed or slipped on something, and the incident report is filled out as required, and then it's stuck in the chart, if it's a paper chart, then it's part of the medical record then. Remember that an incident report is really a quality report, and so even if it's protected by law and saying that incident reports are not discoverable, if somebody sticks it in a patient's medical record and it remains there, then if that medical record is subpoenaed, that's part of the medical record then, that incident report. So we don't put incident reports on the medical record. I have known of incidences where someone's putting a record together or assembling a record, and again we're talking about paper records here, on discharge, and come across, okay, here's an incident report. It should be immediately removed and sent to the appropriate party, and there will be a policy in the hospital or the healthcare facility, and it tells who gets the incident reports and how they should be filled out. So they should be labeled as quality assurance records or reports for the hospital lawyer, and also never kept on the medical record. That's the biggie with the incident reports. So here's some practical tips for protecting incident reports. Treat and label them as confidential. Again, they're not part of the medical record. Limit copies made. There really should never be any copies made of an incident report. It should just be filled out and then sent to the appropriate party. I've already said that 3 times. Don't put in the medical record. Limit content of the report to only the facts. Now, normally we wouldn't be filling out an incident report unless there was an incident in our department, something happened there. But a lot of times these are filled out by nursing service because they pertain to a patient that's being treated. And what if, and here's a good example, something you might not normally think of, is you walk into the room and the patient is on the floor. And the patient says, or the patient's family or something, he fell out of bed. Well, the person that walks in, the nurse, didn't witness that. So on the incident report, it shouldn't say patient fell out of bed. It should only state the facts. Patient found in floor. Patient's family or patient's spouse stated that the patient fell out of the bed. So if it's not witnessed, don't write it down. It shouldn't be written as a fact. And so the people that are filling out these incident reports should be trained on how to fill them out factually, based very, very objectively. Don't assume anything. They should be addressed to the hospital's attorney or claims manager by name. That would protect them. And as I mentioned, train the personnel in completion and maintenance of incident reports. Everybody that could possibly be completing these needs to be trained during an orientation period on how to do these and how to fill them out and where to send them, and don't put them on the medical record. They need to be treated as quality assurance or QA, maybe more familiar with quality improvement, QI. And again, I know you haven't had your class in quality improvement yet, but that's a particular function within the facility. So that's the information on discovery and or admissibility of medical records.